Hey everybody, I'm John VanDuzer, CPA and partner with James Moore and Company, and I'm here with Phil Kabler, a partner and attorney with Bogan Munz and Munz. Phil specializes in real estate law, business law, banking, and a little bit of the equine industry. In addition to that, he's a good friend of mine, and he's also a professor at UF and the president of the local bar association. So thank you, Phil, for joining us. So you and I were talking, Phil, and we said, you know what, it would be a great idea if we just got together and maybe did a little video on business law and maybe some general best practices. And I thought that was an awesome idea, so thought we could kind of run through some things. So to kind of touch it off, when you form an entity, I think there are there's three areas that I like to focus on. One is entity formation, two is kind of operations, and then three is, selling or some sort of transaction. So when you form an entity, what are your options for a new business entity?
Well, let me start off with something you're going to like first.
Okay.
My intake interview. My intake interview starts with clients with asking them if they have a CPA. And that's because while I'm looking at informing a business entity, risk, operations, and tax, that tax right there. What we want to do is make sure when we organize a business entity that we don't end up shooting ourselves proverbially in the foot by building a structure and then having it cause an undesirable tax consequence. Now, you, John, and I have done a number of co-formations of businesses, and you know that I like to send the operating agreements for you at least to review. And what your folks who are watching don't know is you've offered considerations that I've included because they work. But the issues I look at are tax, and I don't pretend to be an accountant. I play really nicely with accountants. I look at liability, and that comes out to I teach. I cover, meaning I teach when the tenured professor at Warrington is not teaching, and I teach the undergrad and sometimes grad survey of business law. And so I talk with the students about a variety of things, and you divide business entities into two halves when it comes to liability. Unlimited liability, meaning you can lose everything short of those items that are protected by state debtor law and bankruptcy law. And then limited liability entities. LLCs are one that people think of, corporations, and for particular, a lot of smaller businesses will work with you, with CPAs, and determine to form a subchapter S corporation, which, by the way, is just a regular corporation. It's just a corporation that's taken a particular tax election. So that's, in terms of the risk issue, that's how we divide that off. Operations, who's going to run it? Sometimes folks want anonymity. I've seen entities that have 2 and 3 and 4 levels of managers, and tax and financial issues. Those are the things I look at when we start with forming a company. Do that right, and then it's much easier to proceed into operations. Two of the other questions I deal with, even when we're forming an entity, it's makes people scratch their head. When someone's forming an entity with me, I'm going to say, so tell me, what's your disposition plans with this company? I haven't formed it yet. Well, I know, but we have to make some decisions up front in terms of how you're going to structure it. Or do you plan to hold it? Do you plan to pass it to your family? Do you want to someday give it or sell it to your employees? Do you want to position it, as you said, to sell privately? Do you want to position it someday to go public? And so there's decisions that we make even up front with regard to that.
Right. It all starts with your goals. So one of the areas, or I guess one of the newest entities that we see so much of is, I would say, and I don't know how many you see as a percentage, but I think most new entities I see are LLCs. The traditional corporation is not as frequently used as maybe it was in the past. And
for profit. Right.
the for-profit, and obviously a nonprofit has to be a corporation, but the
Also, but
for-profit.
they also are used with regard to condo associations and HOAs. So
Right.
yeah, they do come up.
But one of the questions that comes up, and I think this is a really good topic to talk about, is what is the difference between a multi-member LLC and a single member LLC?
Okay, so that boils down to a liability issue, basically. They're both LLCs. You form them both exactly the same. The issue is what happens if an owner of the LLC has a liability incident, bad car accident, they're individually sued for something. This is the long story short version because it's far more complex, and it comes out of a case a couple of years ago with the Florida Supreme Court called Olmstead, and with a temporary statute called the Olmstead Patch, which became permanent. Is if I have a single member LLC and I have a liability, a loss that's not covered by insurance, any plaintiff's attorney is going to be starting to hunt around for assets to collect upon. So they're going to see that you, John, you're the sole owner of an LLC. And so they have to go through the court process, but they can collect against your LLC interest, effectively foreclose it and take it over. If it's a multi-member LLC, which is something that I encourage folks to do because, long story short, again, more complex than this, what they can get if they have a liability claim against one of the owners is a charging order, which means when a distribution is made, they can get that. But
Right.
They can't get the equity interest. Now, there are ways around that. It's called piercing the corporate veil. And basically, even though it says the word corporate in it, what it does is if someone runs a limited liability entity for fraudulent purposes or treats it like their own piggy bank or doesn't follow the formalities for whatever that business entity is, and LLCs are very slim, a court in a case can lift the limited liability protection and then make it unlimited liability. So to answer your question, simplest case is single member LLC. It is possible for one to lose their ownership interest. Multi-member LLC, all things being equal, a charging order against distributions.
Right. So that adds that layer of asset protection
Yes.
to your ownership.
And I have that conversation with clients. I encourage them to bring out a partner, as it were, even as a minority.
So why is it important to work with an attorney when you set up an entity? I mean, I think there's a temptation out there to, go to LegalZoom or some website to set it up, and just like there is to go to TurboTax to prepare a tax return. But why is it really important to work with an attorney?
Well, the example I give folks is, I know I have a toothache, but I'm not going to perform self-dentistry. There are people who, accountants, lawyers, other professionals, this is what they do. They keep up with the law, the rules, regulations, in your case, the regulations on accounting, and we're efficient. And we know what we're looking for. We know what to ask the clients. Clients aren't going to think about what's my goal. They're going to fill out the form. And I don't know what you see with TurboTax, for example, but I can tell you over the years, I've gotten a reasonable amount of business from people who used LegalZoom, or I don't want to pick on LegalZoom. I don't have anything against them. I don't know anything, but let's just say the computerized, digitized, artificial intelligence-based products, and they don't know what they're doing, and they do it wrong. And then they need to come in and have someone get out the big lawyer mop and clean it up. And it may not show for a while. It may show, it may be a dispute among owners. It may be issues we just talked about with liability preservation. So the role for having a lawyer, well, a number of different things is when we've been doing it a long time, we have networks. So I know when to call a John VanDuzer and say, this is something the client really should be speaking with you about and not about me. So I suppose in current parlance, it's a good idea for people, professionals, to stay in their own lane. And by the way, I talked about in the last time about proactive risk management. That's spending a little bit more time on front so you don't have to spend more time cleaning up a mess afterwards. So sure, it costs some amount at the beginning to hire a lawyer or an accountant, but when done right, it saves you a lot of headache and issues and problems later on. We also know questions to ask along the way. I've had, and I'm sure you have had, clients who come in and they say, I just need a simple boom. My example is that my first job, perhaps my best, was I was a dishwasher and ice cream scooper, and someone would come in and say, well, I want a cone, single scoop, vanilla. You know what? I want 3 scoops because it looks good. It turned into a sundae. Oh, no, banana split. Why aren't you charging me the same thing that you're charging me for the single scoop of vanilla? Well, it's like unpeeling an onion a little bit, to use a metaphor, and you do that and I do that. They come in thinking they want something simple, but then and I've had this happen. They start off with a company, they overlay estate planning issues. They overlay tax concern. They overlay minority business ownership concerns. So all of a sudden, something which was simple can become quite complex. Oh, and by the way, I want to bring in partners as investors, which for lawyers, big red flag is raised because now we have securities law issues that there either has to be complied with or exemptions from it. So why do you hire a lawyer? Why do you hire an accountant? Because, as industries, we know what we're doing. We're trained, we keep up with, we're educated, we're trained, we're licensed, and we keep up with that over time.
Yeah. And you mentioned the legal mop. You may not realize you need that legal mop until you really need the legal mop, which could be
a lot more expensive.
Yes.
A lot more expensive. And, I don't know what you do, by the way, when you counsel your clients, but one of the other intake questions I have with mine, and I have a number, is who's your insurance agent? I don't really care who their insurance agent is. I want to know that they have insurance. So they get insurance. Pivoting a little bit, one of the biggest issues right now is business interruption insurance in light of COVID. People's, business interruption insurance was traditionally used. There was a casualty, like a building burned down. There's a famous story from Massachusetts where a manufacturer building burned down, had business interruption insurance. While his building was being reconstructed, he kept his staff on payroll, was a big hero. That's the traditional use. Now, all of a sudden, revenues dried up. We stopped. People still have bills to meet. They've got to meet their rent. They've got to meet their insurance. They've got fixed costs. And if nothing else, they've got to at least try to beat their payroll. And let's set the issue of PPP loans and the CARES Act and the state support programs for business during COVID aside. The question is whether business interruption insurance covers it. And just for a brief, really shorthand discussion, it's the so-called act of God coverage.
Right.
It doesn't, business stops, it covers it. I know that I've always encouraged clients to get it. It doesn't matter about the nature of their business, but BI coverage, type of liability coverage, it's not all inclusive. It's not open-ended. It has limitations. It covers, like any insurance, specific areas. You wouldn't expect your car coverage to cover your house. You may get it from the same insurance company, but they're different. BI is limited, and people in the industry, they do the best they can to predict, and they charge for it, by the way. Their actuaries will determine risk. They'll conduct risk analyses and longitudinal studies and determine what they're going to charge to cover it. Like mold was an issue which has worked its way into insurance over time because they now have ways to determine risk and coverage. Well, issues of, war was covered, shortages of labor, shortage of material, things such as that. But epidemics, viruses, pandemics, civil authorities closing business altogether have not. And that's resulted in denials of coverage. So now I know depends upon which of the sides I'm on or what we're trying to accomplish is now you're seeing people include in force majeure clauses,
Mm-hmm.
carve-outs, again, act of God, temporary abeyance, temporary suspensions of having to perform issues that may be covered by BI coverage. Those two get very close together. One's insurance
Right.
and one is a contractual provision.
Yeah, I think there's going to be some clarifications probably for, coming for the future, I think, in all of those areas. Going back to the formation, when an entity has more than one owner, what are some common issues that should be considered?
Control and money.
Control and
Uh,
money?
Control and money, but control of money works pretty well in the end because people don't start business. Unless there's some sort of artistic type passion underlying a business,
Yeah.
it's people go into business to make money. As I tell my students when I'm discussing risk management, I say you don't go into business to manage risk unless you're a professional risk manager. You go into business to innovate and bring your innovations to market.
Mm-hmm.
And so the issues are, of course, got a pot of money. We got a pot of expenses at the beginning. You got a pot of
Right.
money. How do we divide up the obligation to pay expenses and then ultimately the ability to get compensated at the end? Now, this is a part where you do work with your accountants because in the life of business, folks will loan money into their own businesses, and we need to make sure that it's properly accounted for. So at some point, they are paid. The other side of that is control. Who makes the decisions? Now, Florida used to have, for LLCs you talked about, we used to have two real popular ways for managing, operating an LLC. There was the member managed LLC where we had a managing member, and then we had manager managed LLCs. About 2014, managing members went away. There is no such thing. There are still two forms, two methods you can choose, member managed LLCs and manager managed LLCs, but no longer is there a first among equals. There may be what's called an authorized member, but all they are, they have the ability to sign and bind the LLCs. So those have to be fleshed out. It's
Mm-hmm.
a little easier, I would say, with a manager managed LLC because you can appoint one person to make many, not all of the decisions. Under the Florida statutes, they can't make the major life-changing decisions. They have to go back to the members to do that. But in terms of mundane management, it's a little easier because you have effectively a CEO who reports back to the other managers or reports to the members. In a member managed, now you've got like a partnership. You've got a group of people.
Yeah.
And you have to come up with a process. So money and control.
Now, another area I think that we often talk to our clients about and really point them back to their attorney is maybe planning for some sort of divorce or dissolution, in advance while everything is rosy and everything is happy. So can you speak to some of the mechanisms to do that, to pre-plan a
Yes.
breakup, and
so
what you do to advise clients on that?
Sure. So the first thing is another thing that one of my intake questions is, do you have an estate plan? It's not something I do, but I have partners who do it. And I just say, you don't want to work your whole life, have the fruits of your labor be decided by a well-intentioned man or a woman in a black robe with a law book deciding how your assets get divvied up. That's one thing. I ask them about that. I told you about intended disposition. But here's what I do. In LLCs, I create what's called internally, it's part of the operating agreement, which is like a partnership agreement. It's the rules of the game. A trigger agreement, it's also called a Russian roulette or a push-pull. And
Right.
it says that, if partners, it's a business divorce, but it's prearranged. I call it a business prenup. So if one partner or multiple partners want to get out, they already have the process in place and the method for pricing the ownership interest. Long story short, with the trigger agreement, if you and I are members in an LLC and you've had enough of me and you want to get out, you can do one of two things. You can offer to sell me your membership interest, in which case you're simultaneously offering to buy mine, or you can offer to buy mine, in which case you're saying you could sell me yours. That they go together. But what's important is the pricing process is already, and the closing process is included. Carry that over to corporations, and we do that same kind of thing through shareholder agreements.
Right.
Take that over even further into partnerships, and that would be an element of a partnership agreement. But I agree with you completely. In terms of proactive risk management, that's something that you want to address upfront. It's a lot less. I can't tell you how much less expensive it is. You may spend a little money upfront working out that provision, negotiating it, and working out the language, just like in a marital prenup. But it's a lot less. Discussing it with a transactional lawyer upfront is a lot less expensive than discussing it with a litigation lawyer, commercial litigator at the back end.
Absolutely. And that trigger option, I'm a big fan of that as well. Just given that it somewhat keeps people fair and honest in how they, proceed in that. Because of
you've read mine a couple of times.
Can you speak to maybe non-competes and help maybe us understand, how are they enforceable? How broad can they be worded? Kind of just the general, maybe the quick list on how to understand a non-compete.
Mm-hmm. It's not open-ended. In Florida, there's a statute on it. Florida Statute 542.335 is the statute. It's being reviewed now by the business law section of the Florida Bar, but the limitations on a non-compete are time, geography, and field of limitation. So time is specific in Florida, depending upon whether you have a non-compete from an employee, whether it's from a sale of a business, whether a variety of different scenarios are laid out in the statute. There are different times that one of two things can happen. If you are less than the permitted statutory period, it's a presumption that it's reasonable. Not that it's guaranteed it's reasonable, it's presumption. Mm-hmm. If it's beyond that period, it's presumed that it is not reasonable. So I can tell you my periods are always just a little shorter than the statute. Geography, it has to be reasonable. I mean, if you have a florist shop, let's set the internet aside. You have a florist shop, it may not be reasonable to have a 500-mile radius around it, but it may be in a city or a county, that sort of thing. Throw the internet on top of that, and then it can get a little more complex because, that's really borderless, boundaryless. I mean, our daughter, one of our daughters is abroad right now, and it was our wedding anniversary, but she bought us flowers on the internet from where she was and sent them to us. So, I mean, that's some domestic Gainesville area company doing business with an international transaction effectively. So geography has got to be reasonable, and also field practice. You can't box someone out of their field entirely. So, they just can't be, you have got to be able to define it. And something that I have seen pop up a little bit, or when you're talking about what can be limited in non-compete, it's not just you. People often have referral sources. And so, typically you can't compete with your former clients. You can't solicit them. You can't solicit employees, for example. And then now the question that I've seen arising is, what about people who make referrals to my business? And there is actual case law on that. It's not an open throttle issue. So with regard to all of these, none of them are open throttle. There are limitations on the elements of a non-compete. And just, by the way, just to throw it in there, non-competes are oftentimes paired with NDAs, non-disclosure agreements, from what folks learn.
Yeah, those are all great considerations. And obviously it's not fun things to think about necessarily, but really necessary early on, because like you said, it can get far more expensive.
More fun at the back end.
Yes. Now, when we talk about like going into the operations side and you worked with an attorney, you got all these things set up, how frequently should you check on these things to make sure that they're still relevant? As times change, businesses change, companies grow or contract, how frequently should you be checking on these to make sure that they're still, doing and in line with your goals?
Interesting question, because that is something that I think about. Let me answer it by analogy. Initially, you go to the dentist twice a year, theoretically, to get your teeth cleaned. You go to your accountant at least once a year to review your taxes. My thoughts are that you should be, I mean, certainly it's as needed. You should meet with your lawyer before you make a major decision, transactional or issue regarding employees, a dispute resolution. But I don't have a specific answer because it's really all fact-based. But I would say, just like you were suggesting, periodically. I know that I like to check in with clients every now and then, not charging them, just what's going on. And frankly, I know you probably do the same thing, and that can generate work. It can. That's not the intent. That's cynical. The point is just to, the other part of the analogy was how often you get your car serviced and your oil changed. A couple, 3 times a year, right? So you should put reviews of legal services on, well, as often as you need it. And likewise, by the way, I'll pitch for you accountants. It isn't necessarily helpful for a business client to just go in once a year on April 14th with the shoebox and say, do my taxes. It's a lot better if, as they move into proposed major transactions, at the beginning end, you talk to your accountant. At the beginning end, you talk to your lawyer. By the way, other professionals as well you should talk to, depending upon the nature. Your bank of preference. If you know that there's going to be real estate involved, you may want to talk to a real estate broker of preference to try to get these things lined up all at once. But with regard to lawyers, I mean, as frequently as you think you need to, but certainly before you're going to make a major change. So I've got one thing that I do is I serve as outside general counsel to companies. And so they'll call me as they need something done or reviewed or put together. Either I've trained them or they've trained themselves to know when issue spotting. It's time to call a lawyer. It's time to call the accountant. It's time to call the banker, et cetera.
Yeah. Now, I think you also at one time had a service where maybe for a nominal charge, you would kind of take a look at things, and then obviously, if anything needs to be updated, then that would be a separate engagement. But I thought that was a really neat way to at least help people understand, hey, these are things that need to be looked at periodically. And that buy-sell agreement, when you wrote it when it was just you two working in a basement, may not take into account that you have $1 billion IP now that maybe needs to be thought through a little differently. So I thought that was kind of a neat way to be proactive.
I didn't want to pitch it, but we do have a business tune-up program that does that. We'll sit around, we'll go through a whole variety of different records, in that case for a fixed fee, and then we'll issue spot and work with you on things that need to be addressed. Those are outside that arrangement. But sure, it's the truth. I got the idea when I was getting my car serviced.
Yeah, it's almost like going to the doctor and getting a physical. It's a legal checkup.
Yes.
So to kind of keep on moving here, when businesses are struggling with COVID, how can they protect themselves?
Well, I think they need to revisit their business model. They need to take a look, and I do talk with students about this. Actually, it falls into the proactive risk management discussion. They need to go take a look at their core business. What are they best at? Where are their efficiencies? Where, conducting a SWOT analysis, strengths and weaknesses, those are internal opportunities and threats. External, so what do they have? What do they have access to that can help keep their business afloat as they're trying to either just stay with what they're doing or repurpose their core business, redesign it. And that's going on, but that's what I think folks should be doing. It's a little late to be going out and initially negotiating force majeure clauses or business interruption insurance at that point. But perhaps the fire hasn't started, but embers are glowing, and you want to address them as that starts.
Yeah, no, that's good advice. If we kind of go to the transactional side, maybe, and this is certainly something where I think we've seen an uptick in mergers and acquisitions. I think there's a general theme in a lot of industries about consolidation, where you're having smaller firms maybe getting acquired by larger ones, and they're building larger entities. What trends and changes have you seen?
Well, interest rates are down again. We talked about that with real estate. So it becomes a little bit, there's any number of different reasons that someone wants to buy or sell a business. There are financial reasons and there are strategic reasons. And there are flat out investment reasons. So right now, interest rates are lower, even on the commercial area, business area. And so money is cheaper. And so it's not a bad time to start to look at divisions or operations. I've seen over the last year or two, consolidators, people who are in a kind of a big business, they'll start to go around and buy up small businesses in their area. So now they have regional toeholds in related businesses. So they'll go into a family of business. I've done a number of those in the last while. Cash too, by the way.
Yeah, no, we've seen that a lot. I mean, consolidation is definitely a theme in the accounting industry. So as I follow our industry publications, you see firms getting gobbled up kind of all over the place.
It's not the big eight anymore.
No, it probably will have a resurgence to the big eight, I think, eventually, given all the acquisitions and the rise. What's the difference between a stock sale and an asset sale? I know this is a pretty basic legal question, but I think it's really relevant.
Goes back to liability. The big issue goes back to when I sell you stock or a membership interest in an LLC, I transfer you the equity interest in the ownership interest in the business, the entirety of the business. But I also transfer to you, the buyer, and you assume the liabilities. Now that is dealt with. Those are heavily negotiated, and they're dealt with through indemnification clauses to limit risk. They apply with asset sales. With asset sales, we are selling discrete things, maybe real property, maybe tangible personal property, plant, equipment. It may be, or inventory. It may be intangibles like accounts, insurance claims, etc. So when you're selling equity, you sell ownership interest, and it's bundled with the liability. When you sell an asset, it isn't necessarily bundled with the liability. There's specific due diligence that's done in both cases. There are contractual provisions, indemnification, defense, and hold harmless clauses that perhaps you see. Easiest way to spell it out with an indemnification, which is a reimbursement, is that they're not open-ended. They're always specific as to something. But in a purchase and sale transaction, the seller will customarily indemnify a buyer for claims related to matters that are made while the original owner still owns it. Simultaneously, the buyer will indemnify the seller against items that happen post-closing.
Mm-hmm. Yeah, we also see escrows too, where for some period of time money is kind of held back, and it may take 12 months, 18 months, or some period of time to really catch any of those immediate liabilities that may not be known. But
also tied to value. I don't know if you see it, but I've seen it tied to valuation as well. Is the valuation of the deal true? If it's true, then that money can be released from escrow. If it's not, because as you said, liabilities that were unanticipated show up, it may be returned back to the buyer.
Right, and you may see that, or you may see like an earnout or some contingent payment based on meeting certain metrics, on a go-forward basis. What steps can an owner take to position their companies for a sale? This is something that when we're advising our clients, we don't just say, okay, wake up, it's Tuesday, and I'm going to sell my company today. This is something that's done months, if not years in advance to get there. What are areas that you see could really help an owner position their company for a sale?
Well, I know, once again, this is going to make you smile. But the first thing that I do when someone comes to me and talks about that is I said, we need to bring in your accountant right away because we need to take a look at what your books are. You want to
Right.
sell your business for a particular price, not even getting to the other issues yet. Um, are your numbers, is the data, is the way you keep the data, will that support the price that you want to get? And if not, you may need to adjust your price. It doesn't have to be down necessarily, it can be up. But then there are the efficiency of operations. This, how does your contract and workflow look now and predicted? Are you maintaining your own customer and client base? How are you doing with getting referrals? In-house, how stable is your employment base? Are you keeping folks? Do you offer them, market type at market rate benefits? Because when someone's buying a business, traditionally equity, but sometimes when it's assets, they go along, the employees will go along as well. One of the due diligence areas you're going to take a hard look at is the labor pool and the benefits, for example, that are given to them. You want to make sure that your hard physical assets, whether they're real property or physical property, are maintained and are up to date. You want to make sure that your business is in compliance with the applicable laws, rules, regulations. I mean, for example, you're selling a corporation. Have you bothered, for example, to file your annual report for a while? I'm sure you've seen this as well, where you're getting ready to do some kind of deal, and I asked to see the corporate minute books, and the last minute that I see taken was in 1957 when the company was formed, and nothing has happened since then.
Yeah.
Which raises red flags. And I can tell you with these conglomerators, they really run the train. They're the engineers, and they are very, very specific in due diligence what they're looking for.
Right.
So you want to predict the best you can, what are they going to be looking for? And that, frankly, is the value in bringing in a lawyer or an accountant up front, because we've done these deals. So we know over time what buyers, for example, are looking for and what prices can be justified.
Right. And it helps you mitigate those things that could blow the deal up, in advance before you get there. So on the flip side, then when buying a company, what are your common considerations for that? We've talked about liabilities, we've talked about the labor pool, we've talked about somewhat the valuation or the stability of the financials. What other concerns are there as a buyer?
Well, same thing, but they are the same thing. So I don't want to repeat it, but what I do want to focus on here is the due diligence process. It's not enough just to issue spot and identify those issues. You have to do the drill downs.
Mm-hmm.
So you have to get the financial records. You have to get the contracts or the leases or whatever the documents are. For example, if I'm going to buy your business and you've got 5 outlets and your retail outlets, restaurant outlets, and you're leasing, I want to look at those. Where are you in the life of that lease? How close are you to renewal or extension? Am I buying, if it's permitted, am I buying a franchised operation? So not only now am I looking at the operations, am I looking at the leases, I'm looking at the franchise agreements and what I'm going to be obligated to buy. So really the issues are drill downs. And here's where training matters. I mean, you train accountants to do specific type of evaluations. You train lawyers. We're going to be looking at the books, the records, the employment jackets, that sort of thing. You have real estate brokers who are going to be looking at valuations and the marketability of property that you're going to be buying. So there my observation, particularly with conglomerators, there's not enough information that they want to get. They want to get everything they can get. They want to sift through it and then decide. But drill downs in due diligence is absolutely critical when you're on the buyer side. It's not enough just to have a big stack of papers. You actually have to look at it and figure out what they are telling you. What's the story that they're telling you about the business now? How am I doing? And in the future, how am I going to be doing?
Yeah, no, that's great info. Well, we're about out of time. So Phil, thank you so much for all of your insights and all of the information. I really appreciate it. I think this is great, great information that people need to know. So thank you.
Thanks for having me.
Awesome. Check out our website, www.jmco.com, for more insights and great information like this. Thanks, guys.